Materiality.
Materiality. So we should take stock, because this is where we come into what I would regard as pure respondents' notice territory. Up until now, we've dealt with matters of appeal, even though they may be tinged with respondents' notice points. But of course, the point to be made is if the appeal fails on either ground, either in relation to knowledge or inducement, then these respondent notice points don't count for much. Where they become relevant is if the insurers succeed on their appeal. And we say if that comes into play, then we say for other reasons the judge could have come to the same conclusion that the defense based on unfair presentation fails. And the first of those reasons is materiality. Now, the judge did hold that the criminal charges were material, applying the recognized prudent insurer test under Section 7, subsection 3 of the Insurance Act of 2015. I haven't taken the court to that section, but I'm happy to do so if it helps. In the context of this, where the judge made some, what I would describe as interesting observations, is that she firstly made a number of factual findings. You can see that starting at paragraph 235. At page 219 of the judgment. And I'm just going to point out some. She makes a number of points from 235 to 241. I'm just going to draw the court's attention to a few of those points. The first is that the criminal charges here relate to a person who has no direct involvement in the subject matter of the insurance, that is the operation or management of the vessel. And they could not plausibly have increased the risk of detention, whether from smuggling or otherwise, because Mr. Bayraktaris' lack of involvement in the trading or operation, because of his lack of involvement in the trading or operation of the vessel. There was no reason, the judge found, for a foreign state to detain the vessel because of Mr. Bayraktaris. If the vessel was detained because of smuggling, it would not be because of anything to do with Mr. Bayraktaris. And then at 237C, which is at page 220, and I've referred to this already, she says the only conceivable way in which the charges against Mr. Bayraktaris could affect the positions of the insurers under the policy would be if the vessel were detained for some other reason, and it then subsequently came to light that there were charges against the director of the owning company, with the result that the investigation was prolonged or more expensive to resolve. This, I accept, is a possibility, although it seems a rather remote one. Now, I'm going to come back to that, but you'll see as I develop my submissions, there are essentially two grounds upon which the judge, I think, relies upon in order to make a finding of materiality, and this is one of them. And I'll come on to the second one momentarily. The judge goes on to find in the next paragraph that difficult to see how charges against Mr. Bayraktaris could have increased the risk of a fraudulent or inflated claim, as he had no role in the procurement of the insurance. There was no reflection on the good faith of NGM. The judge makes this point at paragraph 237E on page 221. Then at 238, the judge says, insofar as objective relevance to the risk is a necessary precondition to materiality, which is by no means firmly established, I find that the circumstances relied upon by the insurers had no objective relevance to the risk of loss or liability under the policy or to the probity of the claimants, save for the rather remote possibility identified under 237C. This is the possibility of a prolongation of the detention by other means. The judge goes on at paragraph 239 to say that Mr. Wickborg, expert evidence, who was the expert called by the insurers, he was unrealistic and intransigent. And at 239, I think she, in the last sentence, on page 222, sorry, I beg your pardon, about 6 lines from the top of the page, he says, I cannot accept his general proposition that no prudent underwriter would insure a vessel insofar as the assured had some sort of association, however remote, with a person facing criminal charges who had no role in the management of the company or the ship. As a statement, this seemed to me to be far too broad, and even Mr. Wickball was ultimately constrained to accept that the criminal charges themselves were not material for the policy in this case.
Being the sole director is not really a remote relationship with the company, is it? Even if you act on instructions.
No, but I think Mr. Wickball's evidence is the association, however remote, meant that it was automatically, as far as he was concerned, material to a prudent insurer. Now, he qualified that in his cross-examination, but that was his evidence. It's not to say that Mr. Bayraktaris's directorship of Delos was a very remote circumstance. That's not what. He was looking at it from a general position. And then, so the judge says in the last sentence, the second last sentence, as a statement, this seemed to me to be far too broad. This is dealing with the general proposition. And even Mr. Wickball was ultimately constrained to accept that the criminal charges themselves were not material to for the policy in this case. He also accepted that if NGM had not known about the charges, their probity could not be impugned. So that's the judge's finding. Then, in paragraph 241 on the same page, the judge says, all that said, I do accept insurer's submission that there is, from a prudent underwriter's perspective, something undesirable about insuring a vessel which is associated, at least on paper, with someone accused of being a member of an organized crime gang. And then there's a comment about not accepting my client's expert evidence as equally unrealistic, she says. Now, there are 2 points the judge relies on in relation to materiality, I would submit, are first, the remote possibility that a vessel detained for other reasons, that detention might be prolonged by reason of the charges brought against Mr. Bayraktaris. And the second reason is, notwithstanding the finding that other than that remote possibility, there's no objective connection between the charges and the risk being insured, and there's no issue of moral hazard, nothing to implicate the good faith or bona fides of NGM, that the judge ends up saying there's nonetheless something undesirable. Now that's, I would submit, is a subjective evaluation which is not relevant for the purposes of identifying what materiality means in this context. So what do I mean by all that? Well, what I mean is, firstly, there is this requirement on my submission that in order to be material, it's not just a matter of what's material to a prudent insurer, as the test says, but there's an additional requirement of there being an objective relevance or connection between the non-disclosed circumstance and the risk being insured, or the risk as understood under the policy. And I'll take you, my lady, my lords, to 2 authorities which deal with this. But I can give you an example. So, I mean, the famous example, if I put it this way, it may not be so famous, well, famous to me anyway. The famous example is that is there an obligation on an insured to disclose to the insurer the fact that he or she has obtained quotes, premium quotes, from other insurers which are less competitive or more competitive, however we wish to prove it. So are they matters which should be disclosed? Now, one argument would be a prudent insurer would be interested in knowing what other quotes have been received by the insured, because in assessing the premium. But it has nothing to do with the risk at hand. It's nothing to do with the risk being insured under the policy. So even though in one sense it might satisfy the prudent insurer test, it has no objective connection with the risk being insured. Now, the relevant authorities in this context, I'll just take you to 2 authorities if I may. The first one is at bundle, the authority is bundle 3, tab 34. page 996. And this is the Societe Anonyme against Farrax case.
Now, please could you give me the tab again?
Oh, I beg your pardon, my lady. 34, tab 34,
Thank you
page
very
996.
And page 996.
Well, that's
Yes.
just the head
That's the
note.
heading. Yeah.
But I was going to take you to 1029,
Thank you.
which is Lord Justice Hoffman's decision. And what was being alleged here is there is a prudent insurer test, but the brokers who were acting on behalf of the, as it were, reinsured, had information in relation to the validity of the reinsurer's own retrocession. So nothing to do with the reinsurance being placed, but to do with the retrocession available to the reinsurer. And the argument was, well, that must be something which is relevant material to a prudent insurer. A prudent reinsurer would want to know whether or not there's something about its retrocession, which was in question. Now, I should make it clear, there's a separate ground of argument in this case that the broker's knowledge is not attributable to the reinsured, its principal, because that information was acquired in a capacity other than as the agent of the principal. But this is what Lord Justice Hoffman says at the bottom of the first column. So the heading is non-disclosure as to validity of retrocession. In this court, Farrax took a new point on the effect of St. Paul's allegation that Heath Fielding knew that Mr. Carney had no authority to enter into the retrocession agreement. The point applies only to the first year in which the declarations of individual risk were made through Heath Fielding as agent for sale. It says that St. Paul's allegations are true. Sorry, if St. Paul's allegations are true, Heath Fielding knew that there was no effective retrocession agreement. It was therefore a matter which, as agent for sale, reinsured, it should have disclosed at the time of each declaration. It is true that the knowledge was acquired in a different capacity, namely as agent for Farrax to obtain the retrocession cover. The insured and his agent are under a duty to disclose every material circumstance of which they have knowledge, irrespective of the way in which that knowledge was acquired. And then there's reference to sections 18 and 19 of the Marine Insurance Act. And section 18, of course, defines materiality in the same way as the Insurance Act of 2015. In my judgment, the status of the retrocession agreement was not a material circumstance in relation to the retrocession contracts. Section 18.2 defines a material circumstance as one which would influence the judgment of a prudent insurer in fixing the premium or determining whether he'll take the risk. These are wide words, and Tate and Hislop shows that they go beyond matters which are material to risk in the sense of a likelihood and extent of the loss. They can include the likelihood and extent of recovery under the insurer's rights of subrogation. Such rights do, however, affect the insurer's potential net loss under the contract of insurance. It would, in my judgment, going further than any court has gone before if we were to impose an obligation to disclose matters relevant only to the interest of the insurer under a different contract to which the insured is not party. The duty of disclosure is founded upon the likelihood that matters affecting the insurer's likely liability under the contract, including arrangements which may affect the rights of subrogation, will be within the peculiar knowledge of the insured. But this cannot be said of the status of the insurer's reinsurance contracts. It would be pure coincidence for the insured or its agent to have any knowledge of these matters. Now, this judgment was then relied upon by Mr. Richard Sibrey, QC, sitting as a deputy.
Lord Justice Allen and Lord Justice Dillon didn't address that point.
I think no. I think that's. I beg your pardon, my lord. That's. I'm glad you raised it. I think one of the Lord Justices took no view, and let me just. Can I come back to you? But I think Lord Justice Staunton. Is it Staunton and Saville?
It's Dillon. Lord
Dillon.
Justice Dillon.
I think Lord Justice Saville may have expressed a view which is at odds with this, but I will come back to that in a moment. I was going to ask my learned juniors just to. I'm glad you reminded me there. And then the next decision is decision of Mr. Richard Sibrey sitting as a deputy judge in the commercial court in a case called O'Kane and Jones, which is at tab bundle 2. Tab of the authorities bundle. Tab 30. Right at the end. page 910. Oh, maybe in your bundle 3, I'm sorry, it's in bundle 2. I'm not sure why that.
I'm sorry, it was tab 30, page.
910.
Thank you.
Hopefully the page number's the same. So in this case, again, it was a hull insurance over a ship, and the issue was whether or not an indebtedness between an insured and another insured was material for disclosure. This is related to hull risks, and also the fact that the insured had not paid its premium under an earlier insurance contract on time. So there was, if you like, a credit default. And the way Mr. Seibri, QC, dealt with it at paragraph 222 is there was some debate in the course of submission as to the test for materiality. As Wellington submitted, the authorities demonstrate that it's not every matter which a prudent insurer might want to know, which is material to be disclosed. It's not, the concept of materiality is concerned with matters which affect the likelihood and extent of any loss to the insurer under the insurance proposal. Thus, it includes not only matters going to the likelihood of a loss to the subject matter by a peril insured, and then C, Glasgow against Simonson, which is in the bundles, I think, but also matters relating to the likelihood and extent of any subrogation rights. The duty of disclosure is founded upon the likelihood that matters affecting the insurer's likely liability under the contract, including arrangements which may affect rights of subrogation, will be within the peculiar knowledge of the insured, and matters going to the moral hazard, i.e. matters which increase the likelihood of it being made to appear falsely that a loss or damage has occurred, falling within the scope of the policy, as per Mr. Justice Mance in the Insurance Corporation v. Royal. It does not include material which is relevant only to the question of whether or not something is good business, but has no bearing on the likelihood and extent of any loss to the insurer under the insurance. And then the judge goes on, I deal first with the allegation, this is paragraph 223, that ABC should have disclosed the nature of exposure it was seeking to protect. In my judgment, there is no substance in this complaint. The fact that ABC was owed money by Nice, so they're both insured, was not itself material to be disclosed. As Mr. Yule indicated, the provision of financial support by managers to ship owners is not uncommon. Mr. Kent said in his statement that if managers came to him via the broker to say that they wanted to protect their position regarding sums of money owed to them by the owner, he would not have written them H&M insurance, as the interest that they would be looking to protect would fall under the financial guarantee type of insurance. However, accepting cross-examination, the correct view was that ABC intended to effect an H&M insurance on the vessels to protect an insurable interest, that it or its principals, as I find it is, this point fell away. And then about 10 lines from the bottom, it says, as Mr. Yule pointed out, the indebtedness which may have prompted ABC to seek cover does not influence or alter the subject matter or the perils to which the subject matter was exposed and which insurance coverage was sought. And then the judge at 224 makes a similar comment about the non-payment of premiums, and therefore concludes at 228 on the next page, if the late payment or failure to pay premium under a previous policy is not itself material to the risk being insured under an H&M policy, and therefore not disclosable as such. So, now, in those circumstances, what the judge in that case was doing, was clearly influenced by Lord Justice Hoffman's decision, because he cites it, is that unless there's some sort of objective connection between the risk, Lord Justice Hoffman looked at the risk not just as the risk of a loss occurring, but the risk of a financial loss to the insurer overall under the policy. So you can take into account issues of subrogations and recoveries. So, but anything beyond that would not be. So there was it's not in the bundles, there's a well-known Australian High Court case where the issue was the insurer, the underwriter, granted a premium discount to the insured in the belief that the insured would renew the policy for the following year. But actually the insured had formed the view already that it wasn't going to renew the following year. So the argument was that should have been disclosed, and because it was material. Although the materiality test is expressed slightly differently in Australia, I think it's a prudent insured test, not a prudent insurer test. But in those circumstances, the High Court of Australia, albeit in a split decision, held that it wasn't material because whether or not a policy will be renewed the following year has nothing to do with the risks of loss under the policy in question. So that's the approach adopted by the courts in a number of occasions.
Doesn't the judge's example, in fact the only example she gives, of the charges affecting the insurer's position, namely the vessel's detained for some other reason and the charges then somehow come out, doesn't that rather miss the point? The point is that these charges might, during the currency of the policy, turn into convictions, and then the sole director of the ship-owning company has been convicted, potentially in a blaze of publicity, which causes sort of serious reputational loss to the ship owners, at any rate, and a heightened risk if they go somewhere where people want to take a very close look at a ship whose sole director has been convicted of being a member of an organised crime gang. Now, we know now that didn't happen and wasn't going to happen, but at the time it could have.
Well, it depends what impact you say that has, my lord. So, for example, what we're concerned here is with a war risks insurance.
Yeah.
War risk insurance means either there's a danger that the vessel will be lost or damaged by armed conflict, or it will be lost by a detention for political reasons. That is not something which any conviction, if it followed through, would have any bearing on. Now, it may have a bearing on the ability of the owners to deal with other parties commercially. You may have it in that sense, but it won't have an impact on the moral hazard as found by the judge, and it won't have an impact on the possibility of a risk of loss occurring pursuant to a war risk peril.
Well, it won't now, because we know after a trial that this particular sole nominee director was exactly that, a nominee.
But just assuming
the authorities of a state who hear that a ship has come into their jurisdiction are not going to know all that, are they?
No, but I'm assuming the worst. There's no reason I should assume this, but on the assumption that Mr. Barataris was convicted of the criminal charges, just assuming the worst, so that the charges could have materialized into a conviction. I think that was the premise of my lord's question.
Yes.
And I'm saying, even if that were the case, even if it was likely there was going to result in a criminal conviction at the date of the presentation of the risk, that wouldn't have a bearing on the occurrence of a risk which is insured under the war risks insurance. It may have other consequences for the owners as commercial entities, but as far as the risk of loss by armed conflict or political detention, it's irrelevant. And the reason it's irrelevant, no role whatsoever in the operation of the ship. There's no role whatsoever in the preparation or provision or presentation of a claim under the policy. There's no role in procuring policies. Any decisions as to the ship being commercially managed and operated in other jurisdictions is completely outside his responsibility and control, outside. In the same way, I can assure you it's not happened, but if a criminal charge was brought against me as the ship owner's counsel, that would have no bearing on the obtaining of war risk insurance. None. I appreciate Mr. Barataris is more closely associated with the operation of the ship, but the same point obtains.
Well, on this hypothesis, the thing that the insurers might be worried about is that here is somebody who might get convicted of being part of an organised crime gang associated with ships which are smuggling drugs into the jurisdictions where they go, increasing the risk that authorities will look very closely at other ships that he's associated with. Now, there may then be arguments about, oh well, if it's detention for drug smuggling, is that within the exception we were talking about this morning? But that's just something which insurers might well say, I don't even want to go there, isn't it?
Well, all I'm doing is relying upon the findings of the judge. The judge said there was no objective connection between the risks at hand or moral hazard and the non-disclosed circumstances.
But that's because the only way she could foresee the risk eventuating in some way was if the charges came out. And I'm suggesting, well, what about the risk that there was actually a conviction during the period of cover? Wouldn't that be more serious?
No, because I did
say not.
I say not because I don't think there's any difference between charges and a conviction. Because the charges create in the prudent insurer's mind the possibility there may be a conviction. So why would that matter?
You say it's all the nature of that risk is already encapsulated in the existence of the charges.
Exactly. Now, can I just, my Lord Justice Popplewell asked a question about Salem, against Society
Salem Barracks.
Salem Barracks. And I'm just going to just come back to that now. So I think tab 34 of third of the Forest bundle. So the first comment by Lord Justice Dillon, page 1022. There's a reference to Tate and Hislop, second column, and so this is where I think Lord Justice Dillon does come to a view, which is at odds with what Lord Justice Hoffman says. It says, by that test, you can see that paragraph in this right-hand column. By that test, I would be prepared to assume that the facts, if known to Sale, that Mr. Carney had no authority to commit St. Paul to the retrocession arrangement within barracks would have been a material circumstance to be disclosed in relation to the placing of the reinsurance with barracks, since it is obvious that barracks were only willing to accept the reinsurance subject to arrangements of a satisfactory retrocession subject to reinsurance and security. So that's the finding of Lord Justice Dillon. And as far as Lord Justice Saville is concerned, 36, right-hand column. I think bottom, yeah.
Sorry, where are
Sorry, 1036, right-hand column.
we? 1036.
1036, right-hand column. I don't think I'm not sure there's an argument. I don't think the judge, Lord Justice Saville, deals with it. He's looking at 18.3b and he says there's no obligation to disclose the cause of 18.3b, which is knowledge possessed by the reinsurer. So I think he's silent on the point.
Right.
Sorry, I should have drawn your attention to that earlier. Now, if I go back to the judge's judgment, I think it's paragraph, paragraph 214. Sorry, page 214, paragraph 221. So 220 refers to the test of materiality, which is the same under the previous law. Paragraph 221 refers to my argument that in order to be considered material, these circumstances must at least have an objective connection to the risk. Ms. Hopkins disagreed, and this led to a debate as to whether the circumstances must be material to the risk or to the inducement of the prudent underwriter. In truth, this seemed to me to be a largely semantic dispute for two reasons. It depends on what risk is meant by risk in this context, but two, the test of materiality has its own inbuilt limitation in that a circumstance is only material if it affects the judgment of a prudent underwriter, not an ultra-cautious underwriter, not the other extreme, nor at the other extreme a reckless underwriter. As to the meaning of risk, it clearly includes any circumstances which increase the risk of being underwritten if it relates to the risk of loss or damage. to the subject matter, the occurrence or effect of an insured peril, or to the salvage or subrogation rights. Where it's well established that materiality is not limited to such matters and it can extend to moral hazard, and I accept that. And then at paragraph 224, she talks about a debate in a textbook, which she says is not resolved. And I should make it's a textbook I contribute to, so I do recommend reading it because it's very thought-provoking. Maybe at least part of the answer lies in the fact that the test of materiality is limited to circumstances which would influence the judgment of a prudent underwriter. Since it's difficult to conceive of a prudent as opposed to an excessively cautious underwriter being influenced by matters which have no objective connection to either the insurer's liability or potential loss under the policy, or to the honesty or bona fides of the assured. This would make sense because the question is surely whether the underwriter is prepared to write the risk, not whether he or she likes the assured personally or wants further business from the insured in the future, or for good reasons of personal antipathy will not underwrite vessels associated with anyone born in Ruritania. So the judge is basically saying, look, it may be a meaningless debate because within the very notion of a prudent underwriter test, there must be this connection between the information and the risk. And the risk is not just limited to the possibility of an insured peril occurring or a loss caused by an insured peril occurring, but extends also to subrogation and recoveries, and also to questions of moral hazard. So bearing in mind the judge's findings, there were no moral hazard issues arising in this case, as far as the NGM and the Mindreas family are concerned, as far as the senior management is concerned. There was no objective connection between the risk, between the information and the risk, save for the remote possibility of the prolongation of the detention. With those findings, the judge has also said at the end, but I accept there's something undesirable about this possibility, this factor, which may influence a prudent insurer. Now, we say that the judge's decision on materiality is wrong for two reasons, for the two grounds relied upon by the judge. Given all the other findings the judge has made, that the issue about the remote possibility of a detention being prolonged by virtue of the existence of these charges is firstly a remote possibility, not a likely one. But secondly, there was no evidence which suggested that before the judge. I think the closest it comes.
Does it have to be a likely one?
Well,
It might influence the prudent insurer if there's a risk. Mind it?
That's possible. And if there was evidence supporting that analysis, that may be the answer to my respondent's notice. The question is, was there evidence of such a possibility expressed by the experts or even by the underwriters? And I say no. And just on that...
So it's not that she found that there was a remote possibility, it's that there was no evidence
to
support the finding of any possibility.
I mean, the fact that it's remote possibility helps, as opposed to a very likely possibility. But yes, you're right. And as far as that is concerned, I think, just to make this point good, if one goes to paragraph, the evidence which is relied upon by the insurers in support of this is at paragraph 38.1 of their skeleton, which is tab 4, page 72. And this is referring to the cross-examination, I think, of Mr. Whitborg, which is the insurer's expert. And you can see the quotations. I think anyone who is involved in, rightfully or wrongfully involved in illegal or alleged legal activities will represent an enhanced risk and its material, and will be a reason for an underwriter to decline a risk, because the underwriter would simply like to avoid the possibility of being drawn into something that they would not like to be involved in. Now, pausing there, we say that's not referring to the risk of a prolongation of a detention. It's just referring to the fact that the prudent underwriter wouldn't want to, on his evidence, wouldn't want to insure this particular risk. And then smuggling may be, this is on the next page, smuggling may be used, or organised crime may be used by the authority of the country as an excuse to detain the vessel. And that detainment itself means that the war risk underwriters might be involved in the case that might be time-consuming, expensive in order to resolve the coverage issues under the detainment part of the war risk policy. There, whilst the evidence given by Mr. Woodboard is that the criminal charges might be used as a reason to detain the vessel, that was firmly rejected by the judge. So that wasn't a reason why the detention would be prolonged. Now, as far as the second reason given by the judge, which was there's something undesirable about it, that's divorced from the analysis as to whether or not there's an objective connection between the information and the risk. It's just it's a subjective evaluation, and that's not something which we say is a relevant consideration in determining whether or not something is or is not material. If you accept my premise as to the requirement of this objective connection between the risk on the one hand and the information on the other. Anyway, that's my respondent's notice point. A very interesting point, I would add. But in addition, can I just make another point which relates to a point raised by...
I have a sense we're going to be a footnote if we're not careful.
I'm sorry?
I have a sense we're going to become a footnote if we're not careful, Mr. McDonald.
Oh, if,
It depends how we decide it. Will either be an obscure footnote or will be in
a whole
bold.
paragraph. Yes. In any event, I'm sorry I interrupted.
No, I'm glad you made that point. So the and then the other point, my learned friend yesterday, this is just for your reference, transcript page 123, made some, I think, comments which I think she was dealing with constructive knowledge, was bearing on, this is whether or not an inquiry should have been addressed to Mr. Bayraktaris as part of the, whether or not the insured ought to know something. And the, Ms. Hopkins, my own friend, said that, well, there could be scenarios where legal proceedings are served on Mr. Bayraktaris, or statutory demands are served on Mr. Bayraktaris, or maybe issues of moral hazard, etc., etc. Now, it really depends what my little friend's talking about. But this, I would add, this is all speculation. There was no evidence whatsoever about this. And as I understand it, and I'm not giving evidence, I just understand that if this was an issue, it would have been explained that any notifications of legal proceedings would come through the corporate registry and would be advised to the managers as opposed to Mr. Bayraktaris. He wasn't there as a recipient of legal proceedings or statutory demands. And any moral hazard issues would be brought to the attention of NGM. So I'm not sure what this adds, but it certainly does add anything to materiality, I would say, as far as war risks insurers are concerned. Now, the only thing it could possibly refer to is civil claims being brought, if that's what's meant by statutory demands or legal proceedings against the ship, for example, a ship being arrested, but they're traditionally excluded from war risk cover. Because
I don't think she was dealing with materiality. I think she was dealing with
constructive knowledge.
And circumstances in which it might be useful to ask Mr. Bayraktaris something which other people might not know.
But I think that's right, but my learned friend also framed it by reference to materiality. And because I didn't deal with it under constructive knowledge, I thought this was a good spot to deal with it. So, but if you want to put it under the constructive knowledge head, that's fine. I agree with that. But if you want to deal with it under materiality as well, that's fine as well. But the same point arises. Whatever the position of the nation in these proceedings, it wasn't the subject of evidence, but these are not reasons why you would address a reasonable inquiry to Mr. Bayraktaris. Then I'm going to deal with the last 2 points, hopefully reasonably quickly. The first point is, first of the last 2 points is affirmation. And the affirmation point was obviously pleaded, wasn't responded to in the rejoinder, I don't think, I could be wrong. It was fully argued at trial with evidence, and there was no final decision by the judge. But the judge said the affirmation point was distinctly arguable. I think that was the phrase she used. And of course, this point only arises if I fail altogether on the other points when it comes to fair presentation. So it may not be an issue at all And the point is a simple one. Affirmation, it represents an election by the insurer to affirm a contract as opposed to avoid a contract. So that.
But before you get completely launched, if we get to this stage, do you suggest that we ought to decide it or that it ought to be remitted?
I'm in your hands on that front. I don't mind if you deal with it. It makes economic sense for the court of appeal to do it because the evidence is there. But it can be remitted to the judge if that was felt to be a more prudent way forward. But I don't insist on either. Although I insist on one. So there has to be one of those two. And of course, the requirements of affirmation are, firstly, that the insurer has actual knowledge of the circumstances which give rise to the non-disclosure and has actual knowledge of the legal right to avoid. In addition, there has to be a communication, a representation, whether by words or by conduct, which clearly represents to the insured that the insurer has made an election to affirm rather than avoid. They're the requirements. It's not a stopple, so there's no additional requirement of reliance, for example, by the insured. The authorities are well known. I can, of course, take you to them if they're thought to give assistance, but we do rely upon, just for your note, the summary given by Mr. Justice Jacobs in ABN AMRO, which is Authority Bundle 1, Tab 1, page 37, paragraphs 486 and 489. Now, if we go to my skeleton, which is at Tab 5, page 103, you'll see at paragraph 48, there's a relevant timeline, which is that the insurers became aware of the criminal charges by the end of April 2021. And the purported avoidance occurred on, you'll see in A 48.4 in October, which is 6 months later, or 5.5 months later. Now, in paragraph 48.2, it stated that on the 14th of April, the insurers served their defence, in which they advanced two different non-disclosure defences, not this one. But both of those defences did not involve an avoidance of the policy. And 48.3, my client served a request for further information of the defence. And at the end of June, 28th of June 2021, the insurers served a response which continued to assert rights under a valid insurance contract, in particular the breach of the duty to sue and labour. And in those circumstances, we say that those rights under the insurance policy were being referred to and relied upon in a statement of case, which was not at that stage subject to any reservation of rights and served. And in so doing, with their knowledge of the non-disclosures, the insurers affirmed the policy in question.
Well, that addresses the first and the third of the requirements. But what do we get out of that as to when there was knowledge of the legal right to avoid?
You mean in October?
Well, when on that chronology
was there?
Do you say that they had knowledge of the legal right to avoid before they did what you say was the unequivocal
there's also authority
affirmation on the 21st of May?
Let me. I should take you to the authorities, because when it comes to knowledge of the legal right to avoid, if an insurer is being advised by solicitors, as they were at that stage, the court is permitted to infer that they had knowledge of the legal right to avoid, and therefore it becomes incumbent on the insurer to disprove that knowledge.
Would they have to, for example, consult an expert insurer to see whether they would regard it as material.
Well, the evidence is, they may not have to. I don't know. But the problem is, the inference is allowed where they're being instructed by where they're instructing solicitors, and they are instructing solicitors at this stage, and therefore it becomes incumbent on the insurer to demonstrate why they didn't have knowledge of the legal right to avoid.
Well, I'm not sure adding the solicitor adds very much to the argument. The question is whether you can move straight from actual knowledge of the charges to actual knowledge of the right to avoid.
In normal circumstances.
Well, no, in the circumstances of this case. You haven't shown us any findings that the judge made about that.
No, and the judge
we don't know what the evidence was about what was going on. But all I'm saying is I can see that there may well have been things that it was reasonable for them to have been doing after just knowledge of the charges, before it could be said, even with the advice of a solicitor, that they had actual knowledge of the legal right to avoid.
I will be relying on the legal principle, but I can see the point my lord is making. And if that's the case, and it requires a closer consideration of the evidence, then it may well be that if this becomes a live issue, remission is the right answer. If that's the point I think being raised by my lord. But insofar as we say that there is an inference permitted to be drawn in these circumstances of the case, that the insurers had knowledge of the right to avoid, bearing in mind they were already aware of two other non-disclosure defences which they're advancing. So they're clearly aware of what the legal position is. They've become aware of this additional point on criminal charges. And when it comes to the evidence,
which you say wasn't material,
which we say was not material.
So,
but of course,
it might have been prudent for them to take some advice on the question.
Yep, true. But this assumes this where I'm wrong about it.
Well, yes. But
yeah. So I mean, you're right. I don't think
it's at least open to debate on your case.
I see that. Yeah, I see that. But now, for what it's worth, you will see in the transcript of tab 30, page 199, where this chronology was gone through with the underwriters. And the upshot of it, as of what I should do is, if you go back to the insurer's skeleton, this is tab 4, page 75. You'll see the insurers identified 5 stages of this process. The first stage, paragraph 43.1, is whether Mr. Lavignol would have done anything different had the charges been disclosed. And the evidence is that that consultation took place in April 2021. The second point is Greek lawyers had to be identified and instructed to conduct investigations into the charges themselves. This was the subject of discussion with the witnesses. And the evidence, I think, takes you up to the April or May of 2021. The third point is materiality of the charges had to be investigated. Inevitably, this involved identification and instruction of an independent expert underwriter. And time was required for this. I think the evidence was this takes you up to the end of May 2021. And then you've got the fourth and fifth statements, which is a draft amended pleading needed to be prepared. Mr. Dinefle agreed during cross-examination this could only be done at the conclusion of the first 3 stages. And then Greek lawyers had to advise on the risk of a defamation claim. Now, of course, the knowledge of the right to avoid has nothing to do with the 5th step, because that's looking at other aspects, whether or not the right to avoid should be exercised. Now, as I say, this issue was discussed in evidence with the underwriter at page 199 of the supplementary. tab 30. And so on the left-hand column of tab 9, it's divided into 4 pages. So page 178. I hope that's clear.
Sorry, which page of the bundle are you on?
199?
The 199.
19, sorry about that.
No, I misheard you. Thank you very much.
And then 178 of the transcript, which is in the middle of the page.
Thank you very much, Lily. So you can see it, line 23 at page, just next to 178, it's actually page 177. There's a reference to consulting Mr. Lavignol, whether he would have done anything differently. And then the 2 questions. The first question is my understanding of Mr. Lavignol's evidence today was he hadn't been consulted before 2023. He's right about that, isn't he? Well, we had a discussion about this. What dates are you referring to? April 2021. So the discussion with Mr. Lavignol, you say, was in April 2021. Yes. Okay. And then instructing Greek lawyers to conduct investigations into the charges. I don't know why you instructed Greek lawyers, what questions you asked them, what advice you received, but those, I don't want to know that, but those investigations would take time, no time at all. That's the case, isn't it? How long would it take? Yes, it would. It took some weeks. At that time, we chose close to summer time, and it took some weeks to have a full picture about the scope of those local investigation proceedings against Mr. Bayraktaris. I suppose that all of this was not so accessible so fast, so it was not so fast to have access to all those information, therefore it took several weeks during summer. And so when you say summertime, do you mean May? Yes, but still April. May, one must also remember there are some kind of holidays at that time of the year as well, and we're also having kinds of questions when we're talking about the same Mr. Bayraktaris. We had been questions to be sorted out, and it took time to be clarified. And then line 16 on page 179 is reference to investigations into materiality. That would not take long, would it? I cannot be precisely answer it. It all depends on what kind of information we had at that time and how we wanted to appreciate them towards the policy and towards the applicable law, but it was certainly not the longest one, yes. And just looking at A, B, and C, they were undertaken at the same time, presumably. They were taken up one after the other. Why one after the other? Because we had to go through those various phases and make sure we did understand what we were doing with such information. There was no reason why they could not take place why they should take place one after another. Maybe I'm wrong when I say one after the other, but for sure it was not done the same day at the same time. So just looking at stages 1, 2, and 3, on my submission at least, on the evidence, that takes you up to the end of May, certainly before the end of 28th of June. But if the evidence is different, then it's incumbent on the insurers to prove when they acquire the relevant knowledge. So we say with the evidence of knowledge and with the fact that there was no assertion of a right to avoid, but rather there was a reliance upon the terms of the contract on the 28th of June, and that position didn't change until October, then that was an affirmation. Now, the insurers rely upon the fact that there was a reservation of rights in earlier correspondence, in April, May, not specifically regard to criminal charges, just a general reservation of rights. And there was a later reservation of rights in October, but there were none in June. Now, the issue about whether or not one can affirm by a position adopted in the statement of case was accepted by Mr. Justice Jacobs in ABN AMRO, in the decision I've referred you to. But there's also a contrary decision relied upon by, I think, my learned friends of Mr. Justice Leggett in the Galatea or in Volner case. I'll give you a reference to that, which is Authorities Bundle 2, tab 24, page 719, paragraph 179. And from memory, just so it's clear, the inference which I mentioned, which could, as to the insurer's knowledge of the legal right to avoid being inferred if they've instructed solicitors, is referred to in both judgments. And it springs from a decision of Mr. Justice Coleman in a case called More Large against Hermes Credit. Now, I realise I have just dealt with what can be described as a complex issue based on legal principle and evidence in the space of 15 minutes. And it may be something which this court may not feel comfortable dealing with finally, one way or the other. And in those circumstances, remission may well be the right direction. But it only becomes relevant if my clients fail on all other grounds when it comes to their presentation. Then composite policy is the last point, unless there are any questions about affirmation. So on composite policy, just one moment. This may or may not, the position adopted by my learned friends is this, that when they asserted the right to avoid the policy by reason of the non-disclosure of the criminal charges, they did so in their defence by reference to the Delos and NGM, not FML. Now, as far as FML is concerned, when we referred to the composite policy point, there was a rejoinder point raised by my own friends that this also extended to FML. And the idea is, the reason is, that if Mr. Souris, who's the insurance manager for NGM, was procuring insurance for all three insurers, whatever he knows or ought to know should be attributed to all his principals, which would include FML. And that's right as a matter of principle. But that presupposes that the relevant knowledge can be attributed to Mr. Souris in those circumstances, or even NGM if it's relevant, because it shouldn't make much sense. Now, where does the composite policy arise? Policy point arise? It arises in this possibility. If it were found, for example, and I obviously urge you not to find this, but if it were found that this information was known to Mr. Bayraktaris as a member of the senior management of Delos, but there was no constructive knowledge, which was found to exist in the hands of NGM, then one of the possibilities, subject to the other arguments, is there is a right to avoid as against Delos, but not the other insurers. So whether Mr. Souris or even NGM had any knowledge is irrelevant, because they don't on this premise. Now, in those circumstances, NGM and FML would still have a good claim under the policy, because it's a composite policy, and I don't think there's a dispute between the parties as to the implications of there being a composite policy, which is essentially there are separate contracts between each composite insured and the insurers. And just because one insurer is guilty of a breach of the duty of fair presentation doesn't entitle the insurers to proceed to avoid against the other insureds unless an independent breach can be demonstrated against them.
This is just NGM and FML. So as far as the bank is concerned, they are an assignee and can't do any better than
Any of them.
Delos as the...
Well, no, because they're I think they're assignees of NGM as well.
Oh, I see.
Yeah. And FML. So if it were the case that their derivative rights, which come from Delos, are affected by Delos, the avoidance against Delos, it wouldn't affect their rights as assignees of the other two co-insurers.
Right. What claim do the other two have? It's a valued policy, but their interest is simply to earn their fees under their management and technical agreements, presumably. Does that enable them to recover the full 37?
Yeah, and I'm going to take to the authorities. The submission I make to you, my lord, is this, that when you have co-insureds, unless there's a provision in the policy which makes it clear that their interest is insured only to the extent of their limited interest, whatever that interest is, then the co-insured is entitled to recover the full amount under the policy. And there is no danger of over-indemnification in those circumstances, because if it is the case that, let's just assume there were two co-insureds. One co-insured has an interest in the full value of the ship, but the other co-insured, let's say it's a ship manager, has a limited interest, which is, let's say, a quarter of that, just assume. The manager could still recover the full amount, but would then, what the law has done is create what was originally described as a trust, but now described as a personal obligation to account to the true owner for the full value of the policy. So in those circumstances, the manager can recover the full amount from the underwriter, keeps the 25% for himself, but then accounts to the true owner for the remaining 75%.
Where the true owner doesn't, on this hypothesis, have a valid claim.
Correct, because the policy's been avoided.
Well, you may well be right, but it seems rather odd that the true owner, who is deprived of their valid claim because they're in breach of a duty of fair presentation, nevertheless gets the money by that route.
Well, let me put it this way. You have a very strict set of principles which deal with the duty of fair presentation and the possible avoidance. You have a strict set of principles of what a composite policy means and does. And you have a set of strict principles which have been developed over a number of cases which identify how much a person with a limited interest in insured property can recover, and then what they're supposed to do with the additional funds.
When you put all those strict principles together and stir the pot, you get a very odd result.
Well, you get the result I asked for.
The slip in this case talks about all the people being insured for their respective rights and interests.
Yes.
Is that not sufficient to show that,
no.
That's what's being insured?
No, I would submit not. So you would need more to demonstrate because what is clear is the value recoverable in the event of a claim is the value of the ship, an agreed value policy, whatever. So under Section 68 of the Marine Insurance Act, that is the amount recoverable, full stop. The respective rights and interests doesn't refer to the quantum of the interest, it refers to the existence of the interests. And because you have a limited interest, and I'll take you to the authorities in a moment, it's not an answer to the ability of that person with a limited interest recovering the full value, unless there's an express provision in the policy. That's my submission. Now, so having said all that quite boldly, let me take you, if I can take you to the submissions, which I will begin. And I should add, the judge did not address this point. I didn't even say it was arguable or not arguable. So she just said she doesn't need to, or something, or what it was, something like that. So if I can ask you to, I don't think I need to take you any authorities on composite policies and what the effect of a composite policy. I don't think there's a dispute between us on that. That's lucky. And then authority bundle 2, tab 25. Is a decision of Mr. Sumption, QC, sitting as a deputy judge in Lonsdale at Thompson against Black Arrow. And I don't need to worry about the facts. I just want to take you to the principles. Oops, sorry, there we are. And it's page 766. And I suppose it's letter D. The question whether the measure of the insurer's liability is limited to the injury done to the landlord's reversion, so this is landlord and tenant, therefore depends not on any overriding principle of law, but on the terms of the policy. Insurances on property are prima facie to be construed as contracts of indemnity. Subject to the express terms of the policy, the measure of indemnity is a diminution in value of the thing insured as a result of the operation of insured peril. And parties may agree that the damage suffered by the thing insured will be assessed on some agreed basis. There may, for example, be an agreed undamaged value, so agreed value provision. There may be a provision such as the one found in this case, the cost of reinstatement, which would otherwise be no more than evidence of the diminution of value, shall be the measure of the insurer's liability. But provisions such as these do not prevent the contract from being one of indemnity. They merely require the value of the indemnity to be calculated on conventional facts. It remains necessary to look at the particular position of the insured. In the next paragraph, If the insured has only a limited interest in the property, being, for example, a tenant or a reversioner, a trustee, a mortgagee, or a bailee, the value of his own interest may have diminished by much less than the value of the property or the cost of its reinstatement. But it does not necessarily follow that if the insured recovers the whole diminution in value of the property or the whole cost of reinstatement, he'll be getting more than an indemnity. That must depend on what his legal obligations are as to the use of the insurance proceeds when he has got them. If he's accountable for the proceeds to the owners of the other interest, then he will not be receiving more than an indemnity if the insurer pays the full amount for which the property was insured. This will be so whether the insured is accountable to the owners of the other interest as a trustee of the proceeds of the insurance, or simply on the basis that he owes them a contractual obligation to pay those proceeds over to them or to employ them in reinstatement. None of this means that a party with a limited interest who insures the entire interest in the property is insuring on behalf of the others as well as for himself. But he's not insuring as an agent with the others as principals, whether undisclosed or not. All that it means is that his obligations to the use of the insurance monies, once they have been paid, are relevant in determining whether he will recover more than an indemnity by getting the measure of loss provided for in that policy. And then the judge refers to the example of a trustee, but I was going to go on to page 768, the next page. And these principles largely spring from two cases. One is Waters against Monarch Fire, which is referred to at 369, but on 379, you have the decision in Thomas and Hepburn, which is a decision of the House of Lords, where Lord Reed, letter C, stated, a bailee can, if he chooses, merely insure to cover his own loss or personal liability to the owner of the goods, either at common law or under contract. And if he does that, of course, he can recover no more under the policy than sufficient to make good his personal loss or liability. But equally, he can, if he chooses, insure up to the full insurable interest, up to the full value of the goods entrusted to him. And if he does that, he can recover the value of the goods, though he has suffered no personal loss at all. But in that case, the law will require him to account to the owner of the goods who has suffered the loss, or as Lord Campbell says, he'll be trustee for the owners. I need not consider whether this is a trust in the strict sense or precisely on what ground the owner can sue the bailee for the money which he has recovered from the insurer. The fact that a bailee has an insurable interest beyond his personal loss, if the goods are destroyed, has never been regarded in any way inconsistent with the overriding principle that insurance of goods is a contract of indemnity.
But this doesn't deal with a situation in which the contract directly with the, if I can call it the main insured, has been avoided.
No,
This is just a general principle.
Yeah, of course it is. And I'm not aware of any authority which, but of course, if the contract is avoided, my lady, the result of that is there is no contract with, in this case, Delos, but there's still a contract of insurance with others who may not have a full interest. I mean, they may, but they may not have a full interest in the full value of the ship. I suspect the commercial managers will, NGM, who also have other interests, but it may not be the FML, the technical managers will. But the whole point of avoidance is to just set aside the contract. And it's almost as if you start with, in this case, NGM and FML, taking out a policy in their own names and not in the name of Delos. So these principles would still apply on my submission. It has nothing to do with whether or not there is a right of avoidance. Again, a person who happens to have an interest in the policy but who's actually not a party to the insurance contract. And they're not a party because it's been avoided. Okay. And I'm not aware of any authority where these principles have been swirled together and where these issues have been raised. I don't know.
There must be quite a lot of cases.
I'm sorry, my lord?
There must be quite a lot of cases where there's been a right to avoid against owners, but not against mortgagees. I mean, there was the original classic case, and that one, I imagine that happens quite often. But mortgagees, in those circumstances, recover full value of the vessel today, rather than the amount of their loan.
Well, in most cases today, it's quite surprising. There are cases where the mortgagee is a co-assured, but in most cases, in a Hull Marine insurance policies, is that the bank will often be a loss payee or an assignee rather than as an independent co-assured. Now, there are exceptions to that, but it's not by far, in my experience at least, not the most common example. I mean, it's true to say, for what it's worth, mortgagees often take out their own mortgagee's interest indemnity policy, which is separate policies. Now, the point which Lord Reed made about whether or not it's a trust or a personal obligation to account, subsequently resolved by the Court of Appeal in a case called DG against Scott, which is, I'm not going to take you to it, but it's tab 1 of the authorities bundle. Sorry, authorities bundle 1, tab 14, page 430, where the Court of Appeal, or just Hobhouse, held that there is no trust in the traditional sense, it's a personal obligation to account. But nonetheless, there is an obligation to account. So the law constructs this obligation to account to avoid an over-indemnification. So the only way around over-indemnification is either to construe the policy to mean that the relevant insured can recover no more than its personal loss, or to allow that insured to recover the full value, but then account to the true owner or others for the indemnity. They're the two possibilities. Now, so with that, we say in these circumstances, if, for example, the policy is avoided against Delos, but not against NGM or FML, and as derivative assignees against the bank, then the NGM and FML would be entitled to recover the full value of the ship, because that's what the agreed value policy does. But they would then be under obligation to account to whomever has an interest, insofar as their personal loss is fully indemnified. If their personal loss is fully indemnified by the indemnity, that's the end of it. But if not, then they have to account to avoid an over-indemnification.
Did you say you were going to show us a case which illustrates that wording such as we have here for their respective rights and interests?
No, I didn't. I don't think I said that. That was my submission. I didn't say I was going to show you a case. If I created an unnatural expectation, I'm afraid that's just disappointing.
I understand. It's simply submission.
Now, my learned friends do rely on one provision, which I'll come to, which is in the policy at tab 19 of the core bundle. I should make it clear that Mr. Sumption's judgment was subsequently approved by the Court of Appeal in a case called Nash, Hogan and Murray, which is Authority Bundle 3, tab 36, the paragraph 68 to 72. Now, my learned friends rely upon a provision in the policy. I think Mrs. Hopkins referred to it yesterday, which is at tab 19 of the core bundle. Page 374. And it's, the provision is at lines 3 and 4. So obviously this is a policy form, so it says this policy insures blank, and you fill in the gaps. Hereinafter referred to as the assured. If the claim is made under this policy by anyone other than the owner of the vessel, such person shall not be entitled to recover to a greater extent than would the owner, had the claim been made by the owner as an insured name in the policy. Now, if I've understood my learned friend's argument correctly.
This is the whole policy, not the war risks policy?
Yes, but it is, but it's incorporated essentially into the war risk policy.
Okay.
Yeah. So I don't dispute the provision exists in the relevant policy. Go ahead. Now, the way it's put by the insurers, that this provision has the effect that if Delos's claim under the policy fails, then no claim by any other claimant can succeed. I think that's the wrong construction. This is nothing more than dealing with the quantification of the claim. And what it does is make clear, albeit in a standard form wording, says you have to then look at the agreed value policy provision separately, is make it clear that the amount recoverable by any insured other than the owner cannot exceed whatever the owner is entitled to recover. that's why it's framed in the way it's framed. It's framed as a, it just says that other insured shall not be entitled to recover to a greater extent than the owner, had the claim been made by the owner as an insured. So you have to make the assumption that if the owner had made a claim, that sets the limit of how much is recoverable by the other insureds. Now, there's nothing in that wording, we say, which is inconsistent with, first we say the construction given by the insurers is wrong, but there's nothing in that wording which is inconsistent with the other insureds recovering up to the full value of the policy. What they can't do is recover more.
Well, it only makes sense, doesn't it, that clause, if the different insureds might, on their own, on your case, be entitled to recover different amounts.
But they can't recover more than the full value of the
If
ship.
they all recover the same, there wouldn't be much point having a clause which talked about greater extent, meaning the amount.
No, they can't recover. The maximum amount payable is the full value of the policy.
I can quite see that if what that contemplates is parties who are insured for their respective interests, and one can conceive in a value policy, for example, a mortgagee having its own interest which is greater than the agreed value, then you could say, well, that gives some effect to that. What it's essentially saying is it's the owner's maximum claim, which is the maximum for everybody. But if, as you were submitting, the norm is everybody's entitled to the same, what does this clause achieve?
Will it achieve?
In your construction.
Well, it means that if for example, just assuming I take your own example, my lord. If the mortgagee were a co-insured, just assume the mortgagee was a co-insured along with the managers and the owner, but the policy against the owner has been avoided, and the mortgagee's insurable interest is in an amount which exceeds what could be recovered by the owner, because it exceeds, let's say, the insured value, then the insured values sets the limit of the owner's right of recovery if it were a party. And that means the mortgagee, whatever its interest, whatever the scale of the indebtedness.
Yes, but the point I'm putting to you is that assumes
yes.
You've got a policy in which the different insureds are insured for their own interests,
yes.
which can be differently quantified, and that the interests of one of them might, in quantum terms, be greater than that of the owner. That's if that isn't the case, which was rather the premise of your previous submission, it's difficult to see how this works.
No, I don't think it, with respect, I don't think it does, because it seems to me that all this does is set a limit on what can be recovered by any particular owner, or any particular insured. Yes. So let me give another example, if I may. Just imagine it's partial loss which is being recovered. So it's damage done during armed conflict. So it's cost of repair, and the damage done. Let's say the cost of repair borne in part by the managers first, and also by the owners. So let's say 30% of the cost of repair are borne by the owners and 70% are borne by the managers. The managers couldn't recover 70% of the cost of repair. They can only recover 30% of the cost of repair, because that's the exposure on the part of the owners. They've been saved the expense of the other 70%. So that would set a limit as far as partial loss of the managers are concerned. When it comes to total losses, we're in a different world because it's dealing with agreed values. That's what I mean by that.
Thank you.
Excuse me, my lord, my ladies and my lord. I'm sorry. So that's all I want to say about composite policy. Again, a very interesting point, worth consideration. But as far as affirmation of composite policy is concerned, they are respondents' notice policies. But we say they just become irrelevant because of the principal issues when it comes to fair presentation. So if I could just, I've still said I'd finish by 3:30, and that's my plan. I just want to just wrap up, if I may, just just making sure I've got all the points I want covered in relation to both the exclusion and the fair presentation issues. And just by way of summary, so bear with me, and of course, if you have questions, please ask. But the, as far as the exclusion is concerned, we say that it's clear that the exclusion E cannot apply on the facts of this case, bearing in mind this is a case concerning the detention of the vessel by virtue of having anchored in Indonesian territorial waters without permission. That comes nowhere close to the perils referred to in the exclusion.
I think we have these submissions. You made it yourself very clear earlier.
But forgive me, my lady, I just want to make these points. If you tell me to stop again, I'll stop. But can I, if you don't mind, can I just make the additional point? I'm in your hands. If you want me to stop, I shall.
I think we have your points, unless you have some more.
Well, the reason I want to just go through these points is just to make sure there's no uncertainty as to what my submissions are. That's my concern.
I think we have your points somewhere clear about your submissions.
Well, let me say this.
We've bottomed them out, I think, before lunch.
I would submit that the exclusion and the fair presentation defences should fail for the reasons which the judge gave, and the appeal should not be allowed on either ground for the reasons I've given. And I hope that hasn't said too much.
I think we've got that.
But unless, my lady and my lords, there are any further questions, they are my submissions.
Thank you very much indeed. Now, on this side of the House, we have the respondents' notice points and we have a reply. So please.
Thank you, my lady. I'm dealing first with materiality. I can deal with this fairly briefly, I think. The starting point is that we say that materiality needs to be addressed and considered with a degree of realism. We are here dealing with material circumstances that involve an allegation against the sole director, the only person within Delos, that he has been involved and has been charged with involvement in one of the largest heroin smuggling operations in Europe, using commercial tonnage. And the suggestion is from the policyholders that that is something that the hypothetical prudent underwriter would be completely relaxed about, wouldn't even want to take it into account when making a decision as to whether to write the risk or on the terms on which the risk was written. And that's important because that's the test for materiality, set out in paragraph 230 of the judgment. Common ground, therefore, insurers did not need to show the undisclosed circumstances would have had a decisive effect on the judgment of the hypothetical prudent underwriter, or even that he probably would have regarded them as increasing the risk. It is sufficient that he or she would have wanted to take them into account. It's a very low bar. And we do say that it is unrealistic to suggest that that bar is not cleared in this case. Now, said that the judge got it wrong when she found the charges to be material. I understand that the 2 points are, firstly, that the judge applied the wrong legal test, and that secondly, she should have assessed the evidence differently. And we say that both submissions are misconceived. I want to make 4 short points, if I may. Firstly, whilst materiality is usually often proved through expert evidence, given the nature of the charges, they fall into that category of facts that have been described in one of the earlier cases as facts that you do not need anybody to come in and say this is material. And that's the well-known quote from Lord Justice Scrotton in Glicksman and Lancashire that we cite at paragraph 35 of our skeleton argument. And that's relevant because one of my friend's main complaints seems to be that there wasn't the evidence. But whilst often you will have an underwriter coming in, it's not essential for materiality to be proved. And as a matter of common sense here, it seems most unlikely that a prudent underwriter would be unaffected by knowledge of the charges, the seriousness of them, that they relate to commercial tonnage, involve serious organised crime, that's the sole director, and that they were pending when the risk was placed. Secondly, whilst of course every non-disclosure case turns on its own facts, there are numerous examples in the authorities of very similar circumstances having been found to be material. I'm not going to repeat them, we set them out in our skeleton argument at paragraph 36. That's the core bundle tab 4, page 71. And in paragraph 36, paragraph 36.4, we also cite all the textbooks that speak with one voice about the materiality of pending criminal charges. So page 72 of the core bundle. Again, I don't intend to go to those now, but they're all set out in our skeleton argument. The third point is that the policyholder's complaint that the judge applied the wrong test is not understood. The submission was that it was all about whether there needs to be an objective connection to the risk, and that may or may not be a very interesting debate. We've seen that my own friend's textbook has an opinion on it from paragraph 224 of the judgment, and the cases don't speak with one voice on whether the material fact, or the fact that's alleged to be material, needs to have an objective connection to the risk. But this is ultimately an irrelevant debate because, as the court would have seen, at paragraph 238 of the judgment, the judge applied the very test that the claimants contended for in that passage that you've seen, where she says, insofar as objective relevance, the risk is a necessary precondition to materiality. I find that, and the summary of that is, there was an objective connection in her opinion. And the fourth point is that the policyholder's argument that the judge erred in her assessment of the evidence should also be rejected. The objective connection point was established in the evidence. The objective connection was found by the judge in paragraph 237C of the judgment, namely that if the vessel were detained for some other reason, and then it subsequently came to light that there were charges against the director of the owning company, with the result that the investigation was prolonged and became more expensive to resolve, well then that would be something that the hypothetical prudent underwriter may wish to take into account. And there may be even more powerful objective connections, such as those put forward by Lord Justice Males in the course of argument. But it's difficult to argue with there not being some objective connection to the risk. Imagine a scenario where some nation has a particular beef with Greece and some political policy and decides to respond by detaining Greek-flagged vessels or Greek-owned vessels. Could it prolong the detention of that vessel if it came to light the fact that the director of the ship-owning company had been charged with involvement in drug smuggling? Well, potentially it could. It could be used as another reason to detain the vessel for a longer period of time, and particularly where one is dealing with policies where you have a detainment clause, where you have a deemed CTL, effectively, where the detention lasts for a certain period of time. The prolongation of a detention is obviously objectively connected to the risk. And to the extent we need to rely on expert evidence, we do rely upon the judge's summary of Mr. Vickborg's view in paragraph 259 of the judgment that no prudent underwriter should have touched this risk with a barge pole as supporting the position. And the judge, we also rely on the judge's summary, and it's stated in very understated and in very understated terms about and that's at paragraph 241 of the judgment, that from a prudent underwriting perspective there was something undesirable about insuring a vessel, at least on paper, with someone accused of being a member of an organised crime gang. And we say that all these things go into the mix, whether it's the evidence, a matter of common sense, being able to envisage scenarios where it could have an objective connection to the risk, to point to these facts being material. And the final point is that the claimants did rely also on the fact that the underwriters' witnesses of fact and their evidence was in some way relevant to all of this. that's paragraph 46.3 of their skeleton. But we say that materiality is an objective question, and there was some expert evidence. The judge formed her own view as well, but the evidence of the witnesses of fact went to a different topic, namely inducement. So for all those reasons, we say that the respondent's notice point on materiality ought to fail.
Thank you.
My lady, the plan was to take matters slightly out of order as compared with what my learned friend did just now. I am going to deal with affirmation, but so that we're not hopping up and down too much, I was going to ask Miss Aboagye to deal with the composite policy points next. And with the court's leave, can I invite her to come to the front bench so that what she says is caught by the microphone?
Certainly. Miss Aboagye. So you're dealing with composite policy?
I am, my lady.
Mm-hmm.
So I'm dealing with the point my learned friend addressed, which is that even if the insurers are entitled to avoid the policy in respect of debtors, the other respondents will nonetheless be entitled to claim and recover the full indemnity under the policy by reason of the composite nature of the policy. And we say that is wrong. We do accept that because the policy is a composite policy, the interests of each of the assured are several and distinct. And I think that that point has been covered. But we say that it can't be possible that the other assureds nonetheless can claim and recover the full indemnity for four separate and distinct reasons. The first is that my learned friend's submission ignores the clear and express terms of the policy. And that is in the whole clauses at tab 19, which took you to page 374 of the core binder. Ms. Hopkins took you to that yesterday, and my learned friend took you to that a few moments ago.
And it's that wording that
It
we've
is
been
that
referred
wording,
to.
my lady.
Yep.
Not entitled to recover to a greater extent than what the owner, if the claim had been made by the owner as an insured. And we say that if the insurers are right and the avoidance as against the owner, Delos, is valid, Delos recovers zero. And because FML and NGM and the bank as the assignee cannot recover to a greater extent than what Delos would have received, they cannot recover more than zero. Now, my learned friend accepted in closing submissions at trial that the clause does mean that any other assured cannot recover more than Delos can recover. That's not in the bundle, but I'm sure he won't quibble with that, I hope. He seemed to suggest, however, that it was simply a question of a financial cap. But that's not what the term says. The wording is clear, that they are not entitled to recover to a greater extent than what the owners. And I should say, as is evident, that this is a point that the underwriters relied on at trial in written opening and closing submissions. So it's striking to say that the skeleton doesn't deal with it. And today is the first time that I've heard my learned friend's response on this particular point. We say that it is wrong. The second reason, my lady, my lords, is that even if that is wrong, neither FML nor LGM are entitled to recover the full indemnity under the policy. And the first point is that the policy provides, as my Lord Justices Mills and Popplewell identify, that the assureds are insured for their respective rights and interests. Just for your notes, that's at tab 16, page 335 of the core bundle. Now, my learned friend suggested a different meaning to what one would imagine for what respective rights and interests means. And if I may ask you, please, to turn to the case of general accident, fire and life assurance. That's at volume 2 of the authorities bundle. And at page 521, please. I apologize. Tab 17,
Yes.
my lady, my lords. Now, that was a case in which the court was dealing with a clause which said the same thing, respective rights and interests. And if we look at page 521, just about 7 lines down, starting from the amount of his loss. Says the amount of his loss, if the subject matter of the insurance is destroyed or damaged, depends on the nature of his interest, and the covenant of indemnity which the policy gives must, in such a case, necessarily operate as a covenant to identify in respect of each individual different loss which the various persons named may suffer. And you see when you look down to the very last paragraph that the court makes it clear that it's talking about a composite policy, because there was a discussion in that case about whether that should be properly categorized as a joint policy or a composite policy. So that's the definition given where there is a composite policy. We say that it follows that any independent claim by FML or NGM can only reflect their interests as the technical and commercial managers respectively of the vessel. Nothing more.
Was this a valued policy in general accident?
It was valued at, I believe, at 20% of a set sum, and that's in the recitals of the facts at the beginning. So there was a limit to what could have been recovered under the policy. My lady, my lords, the second point is on the duty to account, in which we entirely agree with Lord Justices Mills and Lord Justice Popplewell, that that is not a route that is available to the respondent in this case. It suffices we submit to look, and my learned friend took you to a lot of, to some different authorities. But if I may please ask you to look at the case of the Jackson 5, that is at volume 3. I hope I get it correct, tab 36 of the authorities bundle. Please ask you to turn to paragraph 71, which is at page 1085.
Oh, that's very disappointing. I thought you
Yes.
said the Jackson 5.
So did I.
Just gone 5, I'm sorry.
Sorry, what page did you want?
1085,
Thank
please.
you very much.
So at page 71, you see the reference to the case my learned friend took you to, which is Lonsdale and Thompson. And what the court says there, just summarizing the point to make, is that the two factors that are critical in establishing the insured's right to obtain the full amount of loss for insurers. So that's where the insured has a limited right, but we're talking about in what circumstances can they nonetheless recover the full indemnity under the policy. So those two factors are, first, that the whole interest in the property should have been insured. And second, that the insured making the claim should be accountable for the value in excess of his own interest to the holders of other interest, and will therefore obtain no more than an indemnity in respect of his loss. So my learned friend suggested that there was some sort of automatic principle. And we say not. It's an equitable principle, the duty to account. It is there to ensure that an assured does not recover more than has been lost by them. Now, in this case, we say that simply cannot work. It cannot be right that if insurers have avoided successfully against debtors, that FML or NGL can recover the full insured value of the vessel and the sue and labour claim, only then to account to debtors who thereby obtain by the back door what they could not obtain through the front. We say that that would both be unexpected and it would be unfair, and the court should reject that submission. Further, of course, is the point that if Mr. Shuris failed to make a reasonable search, then Delos and NGM and/or NGM are to be treated as no different, and Ms. Hopkins will address you on that. The third reason we say is that that conclusion is supported by a proper reading of Section 60, subsection 1 of the Marine Insurance Act 1906. You don't have that. We didn't bother you with those authorities, my lady, my lord. But it provides that abandonment is a prerequisite to a claim for a CTL. And we say that in circumstances where neither FML nor NGM had the right to abandon the vessel. So if we look at the ship management agreement, which is at tab 5 of the supplementary bundle, the commercial management agreement with NGM is not in the bundles. But the point is neither of those agreements give NGM or FML the right to abandon the vessel. And we say that supports analysis because in order to claim for a constructive total loss, you have to have the right to abandon the vessel, and that's what triggers the CTL. The last point I think you have, my ladies, my lords, that the bank is an assignee under the policy. And in cases where the insurers have been entitled to avoid against Delos, such that Delos has no entitlement to the policy, we say that the bank as an assignee cannot possibly succeed on a claim against the insurance. And I understand that my learned friend referred to the bank being an assignee of NGM and FML. The same point applies, we will say. If they cannot recover, then the bank as an assignee cannot recover to a greater extent than they would. My lady, my lords, unless I can assist further, those are my submissions on composite policy.
Does the notice of abandonment point appear in your skeleton argument?
It does, my lord.
Where do we find that?
Just find the reference. Page 77 of the core bundle, my lord. Paragraph 49.
Yes. Thank you.
Thank you.
Thank you. And so we come back to affirmation.
My lady, yes, I am the last woman standing. I propose to deal with affirmation briefly, and then I do have some points in reply, but I'm conscious of time, and I will be done by 4:15.
My lady, I do have some points in reply on the
Yes,
responses.
don't
Yeah,
worry.
very good.
Hasn't heard what I've got to say yet. Yes, I will finish in time to give my learned friend a very brief right of reply on the respondent's notice points. I am conscious of that too. Affirmation, my lady, my lords, we deal with, in our skeleton, in the core bundle at paragraphs 41 and following, and so that's core bundle, tab 4, page 74. An initial point is that set out in our footnote 14, which appears by the title, Additional Ground 3 Affirmation. It was conceded by the claimants at trial that affirmation is only in play at all if the remedy is avoidance, and we've given the references to the transcript there. So if the correct answer to the unfair presentation case is that underwriters would have written with a condition, you treat the policy as subject to a condition, wasn't complied with, underwriters don't have to pay, and I know my learned friend says that's not open to me, I'm going to come back to that in reply, but if that's the correct analysis, in the light of my learned friend's concession, affirmation doesn't arise at all. So that's a threshold point. If I'm wrong about that, if I'm wrong about the threshold point, or if we are in avoidance territory, then I do have to address the case that's made on affirmation. The law, can I show you very briefly the neatest summary of which I'm aware of the law, which is Mr. Justice Simon in the Wise case, and that is Authorities Bundle tab 4, I beg your pardon, volume 4, tab 39. And the well-known passage from the learned judge's judgment is on page 1318 of the Ease of the Internal Coordination. And I should say, my lady, my lords, he is summarising a rather longer passage from Mr. Justice Mance's judgment in the Insurance Corporation of the Channel and Royal Hotel case. But it's a nice pithy summary. There has to be actual knowledge of the facts not disclosed. The insurer must also know that non-disclosure creates the right to avoid. the insurer has a reasonable time to decide what to do, and there must be, and I emphasise this, I will come back to it, an unequivocal communication to the assured by words or conduct that the insurer has made an informed choice to affirm the contract. And then item 5, whether that is found depends on how a reasonable person in the position of the insured would interpret the insurer's words or conduct. So the test, in other words, is objective. As to what is relied on by way of affirmation, it is and is only the service of further information in relation to the defence on the 28th of June 2021. Other matters were relied on below, but no longer. And it is right that that pleading, and I'm going to take you to it in a moment, was served before the allegations with regard to Mr. Bayraktaris were first raised with the claimants in correspondence. That happened on the 8th of October 2021, when a letter was sent, and I will show you that presently, by my client's then solicitor, Stevenson Harwood, accompanied by a draft pleading in which the right to avoid was for the first time asserted. Before we go to either of those documents, could I take you first, please, to the defence? In its unamended form, it was served on the 14th of April 2021. And my learned friend has drawn attention to the fact that it included 2 other allegations in relation to unfair presentation, which were not pursued at trial. One related to what underwriters understood to have been a prior detention. That turned out not to be the case. And the other related to the alleged overvaluation of the vessel. There was no mention in the defence of the Bayraktaris charges for all sorts of reasons, but principally because my clients didn't know about them at the point when it was served. But the reason I want to take the court to the defence is that, and we say this is important, it contained a full reservation of rights. Could I ask you please to turn to the call bundle at tab 13, and you will find there the and I fear possibly re-amended defence, looking as pleadings tend to by the stage that they reach trial as if they're suffering some terrible disease, being covered with all sorts of coloured ink. But you can see the original text is, of course, uncoloured, and the relevant paragraph is on page 289. And you see the words reservation of rights. This defence is served under a reservation of all the defendant's rights of whatsoever nature and howsoever arising. So at that point, my clients did not know anything about the criminal charges. They first came to know of them, I'll come back to knowledge in a moment, on the 28th of April 2021. That was when they first heard about them. The claimants served a request for further information some 3 weeks after that, on the 21st of May 2021. And they asked, as requests for further information tend to do, questions about some of the pleas that were advanced in the defence. So they asked about the questions about the unfair presentation defences that were then being asserted, and they asked some questions about the sue and labour case. The further information was served on the 28th of June. That is in the supplementary bundle at tab 11. And in the way of hard-fought litigation, it followed a number of chases by the claimants and indeed a threat to apply to the court. The further information answered the questions that had been asked, and it did not itself contain a separate reservation of rights. But it was not a new plea. It was an elucidation of an existing pleading, which itself contained a reservation of rights. So, against those facts, turning, if I may, to the 3 elements that the claimants need to demonstrate, the burden being on them to do so, to establish affirmation, we say that they cannot make out the test. As to knowledge, we deal with this in our skeleton, core bundle, tab 4, pages 75 to 6. And as we've said there, it is right that underwriters were first made aware of the allegation of criminal charges at the end of April. I've already accepted that. That didn't mean that they had full knowledge, and it certainly didn't mean that they had sufficient knowledge to be able to assert a right to avoid. The acquisition of that knowledge was a process that developed over weeks and months. We've set that out in our skeleton. You've also seen the oral evidence, and I don't really have anything to add to what is there, save this. You will bear in mind that the allegation was and is a serious one, and that underwriters and those advising of them had to be satisfied that it was right and that it was proper to advance it before even raising it, let alone pleading it. Now, in any event, as to the third element, that's to say, the clear and unequivocal representation that the contract is being affirmed, it's our submission that by no stretch of the imagination can the further information be said to be affirmatory conduct. It's not taken alone. It has to be read in context. I've already referred you, and you've seen and you've seen the reservation of rights in the defence itself. What is more, in correspondence before and indeed after the service of the further information, underwriters repeatedly set out general reservations of rights in the widest possible terms. I won't show you all of them, but I will, if I may, show you one, and that is in the supplementary bundle at tab 7. Page 38. This was the 22nd of April. And you will see at the bottom of the page one of perhaps the most belt and braces reservations of rights that it's possible to imagine. But importantly, it also includes the words, that reservation will remain in place until expressly withdrawn in writing. And it never was. At this stage, of course, my clients didn't know about the criminal charges, but on the 11th of May, and that's the next tab, here's another example of a similar communication, also including that very, very clear reservation of rights. And the same wording was included when
must have regarded the first one as somehow ineffective.
It's belt and braces, my lord. It's a very strong belt and very good braces. And then when the issue of the charges was first raised in correspondence, that we see in tab 12 of the supplementary bundle. And it is said, this is on the 8th of October, and it said, essentially, what's this all about? Here's a draft pleading, further reservation of rights. Taking all those matters together, we submit that the service of the further information cannot possibly be regarded as an unequivocal communication consistent only with an informed choice to affirm the contract. 2 further points on that. The first is that while the test for assessing that is objective, it is worth noting, at the very least, we would suggest, that the claimant's reaction to the avoidance case when it was first raised was not to say, whoa, hang on, you've affirmed the policy by your further information. We still have open, I hope, we might still have open, Stevenson Harwood's 8th of October message, but the response to that, we don't necessarily need to turn it up, is in tab 13 of the supplementary bundle. They don't say that. They ask a number of questions, they say a number of things, but they nowhere do they say, hang on, you've affirmed. And that is because, in my submission, no reasonable person in their position would have understood anything of the kind. Affirmation first raises its unpleasant head in the reply. It's a lawyer's afterthought, I'm afraid, as these points so often are. Secondly, authorities. There are two authorities to which I'd like to refer the court, which illustrate what will and what won't be regarded as affirmatory conduct. I don't think we need to turn them up, but I do want to give you the references. The first
Just
is...
to
yes.
clarify your last submission,
Yes.
the claimants didn't know, did they, that you'd known about Mr. Bayraktaris as early as April?
No.
Or that you had known about him before you served your further information?
They didn't. They didn't. But that is context in my submission that is in favour of my case and not in favour of their case. The position might have been different, and I accept this, if there had been correspondence toing and froing in which my clients had said, oh, well, there's this business about the criminal charges, and what do you have to say about that? And we're thinking about whether we might have an avoidance case that we want to assert. And then they had done something which was an express reliance on the policy terms. That, in that case, I accept I might be in some difficulty. And I say that because that is exactly what happened in the second of the cases to which I was going to refer the court, and that is the ABN AMRO case. Reference is Authorities Volume 1, Tab 1, page 6. The relevant page is page 39. So that was a case where possible grounds to avoid had been ventilated between the parties in prior correspondence. The defendants then served a defence which didn't contain an avoidance, didn't contain a reservation of rights. And Mr. Justice Jacobs held in context, that's an affirmation. You floated it, you've talked about it, you say you're sitting on the fence, and then you serve a defence which doesn't avoid. Well, it's scarcely surprising in my submission that an affirmation was found in that case. Contrast, and my submission is that this is much closer to our case, the Galatea, and that's Authorities Volume 2, Tab 24. The relevant page is page 719. And there, it was suggested that the service of a defence without a reservation of rights and with express reliance on policy grounds wasn't affirmation. The difference being the context, and the context in the ABN AMRO case having been the ventilation point. So my submission is the position's quite different here. The defence did contain a reservation of rights. The correspondence had contained the clearest possible reservation of rights, which said that it was to remain in place until expressly withdrawn, and it wasn't. There had been no prior exchanges about the criminal charges. And in those circumstances, the mere service of the further information, itself an elucidation of the defence, in my submission, cannot possibly constitute the unequivocal communication for which the law is looking to find affirmation. My lady, my lords, that was all I had to say on affirmation. Can I then turn very briefly to reply points? And I will try not to repeat myself because it's not helpful to you and it's tempting but not sensible. And with that in mind, I'm not going to seek to reply on everything that my learned friend has said today. A very few points on the exclusion and on what he said on the exclusion, if I may. First, he sought to persuade you that the expression customs regulations means different things in different clauses. And our submission is no. Consider the reasonable underwriter. Not only, as my Lord Justice Mayle said this morning, would he be rather surprised if he was told that the same words in the English and American Institute clauses presented to him on the same day meant different things.
Depends whether he's been reading Bernard Shaw recently.
Well, maybe so. But he would be even more surprised in my submission to be told that the words meant different things in the American cargo wording and the American hull wording that he might be presented with simultaneously. So we say that's a non-starter. And if we're right, and if customs regulations do have a broad meaning, and we say they do, and you've heard my submissions on that, then we say there is a problem with the judge's construction and with my learned friend's construction because it gives no effect to the and similar wording. What then would the reasonable parties to this contract have thought that that wording meant? Well, we say, given the breadth of the wording and similar detainments not arising from actual or impending hostilities, the underwriter confronted with it would actually think, oh well, this means I'm not on the hook for detentions under ordinary peacetime laws, of which customs and quarantine regulations are common examples. The wider construction. And that, we say, is also supported by the, I've accepted scanty, earlier American dicta to which I've referred you. The taking away too much cover point, on which my learned friend placed a lot of store. You have my submissions on that, but just to make this one point, my learned friend did not deal with the fact that what I do submit is the leading text, Arnold, says that the effect of exclusions of this kind is to go a long way to reducing the cover under the capture-seizure clause to King's enemy risks. And Arnold doesn't seem to regard that as in any way surprising. It's not the disaster that my learned friend suggests. If we're wrong about our wider construction, and if you are persuaded that one has to be, shall we say, more granular, then we say that you should look at the genus, the linking factors, because otherwise you are giving no meaning to the and similar wording. And with great respect to my learned friend, we on this side of the court did not hear a convincing alternative genus to the ones that we've put forward, save perhaps what I might describe as a tentative flirtation with a landed goods theory. And that, we say, doesn't work. It doesn't work, or what illustrates that it doesn't work were some of the examples given by the members of the court. What about a detention in territorial waters because the vessel is carrying narcotics intended for a third country? That's smuggling. That's customs regulations. It doesn't work. It would also, in my submission, be surprising if the exclusion was limited to activity within ports, when states generally have jurisdiction, including criminal jurisdiction, over their territorial waters. For what it's worth, the policy in this case states, in a different context, which is what is meant when you're looking at restrictions on going into particular countries and so forth, which of course one commonly sees in war policies. It says that named countries shall include their coastal waters up to 12 nautical miles offshore. That's their territorial waters, of course. And for your note, that's the core bundle, tab 16, page 345. So we say that doesn't work, must be something more than that. And we do maintain the ways in which we have put it. These regulations are about control of vessel cargo and people, or they're about clearances. And customs and quarantine are but examples of those two, albeit perhaps the most obvious ones. Briefly, the Eliza Glacial, have a care. It's helpful to you in my submission for general principles, but there's a limit to how far you can go with it because it is concerned with the meaning of trading regulations, and that is not in our clause. The Institute clauses, the English Institute clauses, have gone down a different path. They've not included the wording at the end, but the words trading regulations have been added. A point which my Lord Justice Males made to my learned friend, he said, even if underwriters are correct and the clause is wider than you say, you suggested to my learned friend that it must have, you could say that it must have been, or it must be directed at regulations concerned with things or people on the ship. my lady, my lords, we would urge you not to adopt that construction for the following reasons. First, we would submit that there is no logical distinction between controlling or clearances relating to things on the ship, people on the ship, or the ship itself. See the port state control example. Let's say port state control detains the vessel because of a problem with her. Well, our submission would be she's not cleared by port state control. That should be within the exclusion. Doesn't feel like a war risk. And lastly, on that point, I would invite you, and again, for reasons of time, I'm not going to turn it up, but I would invite you, please, to go back and look at the Wondrous, which we looked at for a slightly different submission yesterday. That's in the authorities bundle tab 21, which is probably volume 2. It is volume 2. That was a case where there was held to be a threatened infringement of customs regulations within clause 4.1.5 of the London Institute clauses, on the basis that the vessel could not get customs clearance because of each of 1, non-payment of port dues, 2, non-payment of a local tax on freight, and 3, the non-furnishing of a foreign currency guarantee. Those didn't have to do with the goods as such. Certainly the first and second of those did not. So it's not, in my submission, a satisfactory limitation. Rather, my case is better. You'd expect me to say that. Very briefly, as to the relevance of the detention being unexpected, my learned friend made some submissions to you about that this morning. Well, we say that goes nowhere because you do have to look at the similarity of the detention and the regulations. But just a couple of points, if I may. First, however expected or unexpected, the win-win was anchoring without clearance, and in so doing, she was contravening local law, or the master was contravening local law. She was in Indonesia's territorial waters, and she did not have the clearance that was required. She wasn't simply exercising a right of innocent passage. The point is she anchored. If she'd just been going through and she'd been detained, there would have been all sorts of difficulties with that. That would have been contrary to the right of innocent passage under UNCLOS. Didn't accord with Indonesian law anyway. But that's not what happened. And that's why the detention was justified as a matter of local law, because there was a contravention of the requirement that she have a port clearance. If they'd cleared in, they'd have been fine. They didn't, they weren't. In any case, and I make this point in response to a point that my Lady Justice Asplin raised, there is some evidence in the judgment that there had been other instances of vessels being detained under this same law, although in circumstances where there were other allegations also made, such as illegal cargo transfer. And again, for your note, that's paragraph 47 of the judgment, core bundle tab 8, page 151. There was also some evidence, and I'm afraid this isn't in front of you, but I recall it, there was some evidence that there had been a similar sort of set of incidents in Malaysia some years before. I say it's not relevant, but since the point was raised, I try to close it off. Those are all the reply points I had on the exclusion. I don't propose to say anything more about actual knowledge in Delos. You have our submissions on that. Very briefly on reasonable search, we do say that the judge didn't, in the relevant paragraphs of the judgment, ask herself the right question. The right question was, what would the reasonable insured in the position of the claimants have done? Instead, she said that the posited search was pointless. That's not the right question. And indeed, as we've submitted, it doesn't make any sense because she also found that material information was not disclosed. What she should have asked herself was whether a reasonable party in the position of the claimants should have made inquiries of the directors of its special purpose vehicles. We say she didn't, and we say that the only possible answer to the question, if you ask, should they have asked, is yes, for the reasons I gave yesterday. The search wouldn't have been an onerous one. Could have, should have, would have. The statute says what it says, and the word reasonably is used twice. The passages in the Law Commission report and the explanatory notes, so that's paragraphs 886 and 887 of the report and paragraph 57 of the notes, to which my learned friend drew attention, deal in my submission with a slightly different point, which is that a party of whom inquiry is made is not expected to reveal his own fraud or negligence. That's because if you're defrauding your employer, when your employer asks a question, you're probably not going to fess up that you're defrauding your employer. That is a slightly different point, and it is not the same in my submission as saying that it is all right under the Act and the insured is let off the hook under the Act if a negligent answer is given to the question that is asked. Finally, on reasonable search, a note of caution. My learned friend's reference in his submissions to agents to know, be careful, that concept has gone from the new Act. That's an old Act concept, it doesn't help you. Lastly, inducement. We were a little startled to hear that we can't now advance a case based on the judge's finding that underwriters would have imposed a condition. Nothing about that in my learned friend's skeleton, nothing about it in his respondent's notice. We say it's a consequence of the judge's finding. If she is right, and if we are right, as to its not being possible to inquire whether the condition was or wasn't complied with, then underwriters must have a complete defence. If one thinks it through, if the court's hands cannot be tied when it comes to imposing a lesser remedy on underwriters, if underwriters say, well, we would have done this, it can't be right that underwriters have to get that exactly right first of all, and that the court can't say, oh no, the answer is this, this and this.
You say it's a greater remedy, not a lesser remedy, because you're potentially vulnerable to affirmation if you get the knocking out on avoidance.
That I see, my lord, but in terms of the cascade of remedies that are available under the Act, it's undoubtedly the case that avoidance is seen as nuclear, and then there's a series of, if you like, a sliding scale of remedies. Now, on the facts of a particular
Royal
case...
Exhibition means you'd rather win on conventional weapons.
My lord, I will win on any weapons. I'm not fussy. But the point, my lord, is this. It doesn't work practically. The underwriter is always in a difficult position in cases of this kind because he has to consider the hypothetical. He has to consider what he would have done, now in the context of a much wider range of possible options under the new Act, and possibly, if my learned friend is right, which we don't accept, on the basis that exculpatory material comes into the frame. And the effect of my learned friend's case is this. If he says, if the underwriter says, I would have imposed condition X, sets out wording, and the judge at trial says, no, I think you would have imposed condition Y, slightly different, then the underwriter is stuck. And that's simply not realistic in our submission. If, in the light of the judge's findings, if we are right that it's not open to the judge to say, well, the condition would have been complied with, then that's the end of it. We succeed. Very briefly, exculpatory material. The pleading point is this. Nowhere in the pleadings does it, or in the witness statements, does it say, the claimants say that the exculpatory material would have been disclosed on a counterfactual presentation, and that is the point. The binary submission, the submission was made that, oh, well, you don't have a never-ending exchange. This is a binary situation. They say the facts, and that's the beginning and the end of it. The problem with that, my lady, my lords, is that it assumes that the insurer is required to take the exculpatory material at face value. It doesn't work. Much of the material to which the learned judge referred, such as, well, Mr. Bayraktartis would have asserted that he was innocent, or that the claimants would have asserted that he was innocent and believed that he was innocent, and so on. The insurers don't have to accept those sorts of points on the hypothetical broke. It's far more likely in practice that an underwriter would say, well, very interesting, you say that, but we don't wish to investigate that. Why should we? We'd rather go away, thank you. Exactly that point was made by the deputy judge, won't turn it up for reasons of time, in the Berkshire Assets case, Authorities, tab 10, page 330 at paragraph 53, where the learned deputy judge says if an allegation of criminal charges is made, the insurer doesn't have to go away and find out whether it's true or not. He's far more likely to say thank you, but no thank you. Unless I can assist the court any further, that's all I wanted to say by way of reply.
Thank you very much indeed.
Thank you, my lady.
Very quick, my lady, if I may. My lady, my lords, I want to respond to the copies of policy submissions and also on affirmation very briefly. I'll deliver them as bullet points so they're done very quickly. In far as copies of policy is concerned, I do make some points. In so doing, I don't mean to reflect on the quality of Ms. Abaway's submissions, which I thought were delivered very ably, but nonetheless, I do have to make some points in response. The first point is that it was suggested that I presented a contrary argument as to that contractual clause at lines 3 to 4 in the policy wording about the claim being limited to whatever claim can be presented by the Delos as the owner. That is not the case. Paragraph 327 of the closing submissions presented the argument I presented today, no different. Secondly, as far as the general accident provision, the case is concerned, which construed the words respective interest, rights and interests, if one looks at that passage clearly, that makes it clear that it's subject to whatever the policy provides. And we say the agreed value provision is a clear reference to what is entitled to be recovered by any insured under the policy. As far as the duty to account is concerned, the duty to account is a duty created by the courts, not least by the House of Lords in Hepburn and Tomlinson, in circumstances where a person who's an insured with a limited interest recovers a full indemnity in excess of its own personal loss. It doesn't require any independent right of account. It's created by virtue of the fact that the insured recovers more than its personal loss. And I don't think the decision of the Court of Appeal in Jascon 5 says anything different. As far as section 60, subsection 1, this is the notion that the other insureds have no power to abandon. That's a bad point, my lords, and my lady, my lords, for two reasons. One is section 60, subsection 1 is not concerned with the abandonment to the underwriters. That's section 62 and section 61. Section 60, subsection 1 is concerned with the abandonment giving rise to a constructive total loss. This is where the insured abandons a property to the world. So abandons ship, in other words. And the Court of Appeal has dealt with, the High Court has dealt with that in a case called Maceville and Alman and explained precisely what it means. There's no requirement of abandonment in that sense. And in any event, the House of Lords is considered in Ricards against Forrestal. But in addition, there is no reason why any insured who's insured under marine insurance policy cannot abandon whatever their interest in the insured property is to actually make a claim for a total loss. That's open to the insured. There's nothing wrong with that. And indeed, in this case, the NOA was actually tendered on behalf of all co-insureds. Then, just as far as composite policies are concerned, as far as affirmation is concerned, we say the reservation of rights in April and May takes the matter no further. It doesn't really deal with the possibility of a right to avoid. It just says reservation of rights generally. And in any event, it wouldn't be understood as being relevant in the context of the further information which was served in June without such a reservation. And then finally, it was said, I think more forensically than anything else, there was no immediate objection taken to the avoidance when the draft pleading was served in October. But what I can say is once the pleading was served, the plea of affirmation in response was pleaded immediately. When I say immediately, in the next pleading. And that's all I need to address my lady and my lords on, and unless the court has any further questions.
Thank you very much indeed. And thank you to everyone. We're very grateful for your very helpful submissions. Thank you too to people who haven't addressed the court, but no doubt have worked extremely hard in this case. You'll be relieved to know that we are not going to deliver judgment this afternoon. We reserve our judgments, and they will be, the drafts will be circulated in the usual way, which you're very well aware of. Please take care to observe the embargo. If you need to give a copy of a draft to someone else, please ask for permission first. And as you will all be very well aware, we're very grateful for typographical errors being pointed out, but not re-argument of cases. And you'll also be aware that we would be grateful if you would be able to agree consequential issues, and if you cannot, that you write only very short submissions in relation to your differences, and we will decide those matters on paper. Thank you very much indeed.
Court arrived able.